Welcome to day 2 of the regulatory negotiation. My name is Kevin Wagner. I am with FMCS. I'll be the facilitator for the morning session. Agenda, what we're going to go through this morning is we're going to go through a roll call of all the negotiators, the advisors, and the representatives from the department. And then we'll probably pick up with where we left off yesterday, which was the standards of administrative capability. We had a temperature check through M. So welcome. I'll go through the roll call, starting with the accrediting agencies. We have Miss Jamie Studley. You could just say present. Thank you, Jamie. Dr. Laura Rasser-King.
Present.
Thank you. For the civil rights organizations and consumer advocacy organizations, we have Carolyn Fast.
Present.
And Jalen Urban.
Present.
Thank you. Next, from the financial aid administrators at post-secondary institutions, Ms. Samantha Veeder.
Present.
Mr. David Peterson. Okay. He's not present. Next, 4-year public institutions of higher education. We have Mr. Marvin Smith.
Present.
Thank you. And Ms. Deborah Stanley.
Present.
Next, from the legal assistance organizations that represent students and or borrowers, we have Mr. Johnson Tyler.
Present.
And Ms. Jessica Renucci.
Present.
Thank you. From the minority serving institutions, we have Dr. Beverly Hogan.
Present.
And Ms. Ashley Schofield.
Present.
Next, we have from the private nonprofit institutions of higher education, Ms. Kelly Harry.
Present.
And Mr. Emmanuel Guillory.
Present.
From proprietary institutions of higher education, we have Mr. Brad Adams.
Present.
And Mr. Michael Lanois.
Present.
State Attorney General, Mr. Adam Well.
Present.
And Ms. Yael Shavi. State higher education executive officers, etc. We have Ms. Debbie Cochran.
Present.
And Ms. David Sokola.
Present.
As student and student loan borrowers, Mr. Ernest Asuego.
Present.
And Carney King.
Present.
And from 2-year public institutions of higher education, Dr. Ann Kress.
Present.
Mr. William Durden.
Present.
And from the U.S. military service members, veterans, or groups representing them, Mr. Travis Orr.
Present.
And Mr. Barmak Nasirian.
Present.
We have the 2 advisors. We have Mr. David McClintock.
Present.
And Dr. Adam Looney. Okay. From the department, representing the department, Mr. Steve Finley.
Present.
And Mr. Alejandro Reyes.
Present.
And the federal negotiator, Mr. Gregory Martin.
Present.
Okay, thank you. So where we were yesterday was we had got a.
I think you also. I know I'm not.
I'm sorry. I'm sorry. I'm sorry. You were on the Amanda.
Be recognized.
Oh, please be recognized. Amanda, go ahead.
Present.
Okay, thank you, Amanda. Sorry about that. Make a note of that. Where we were yesterday was we were at the standards of administrative capability. We had a temperature check through section M. So I'll go ahead and turn it over to Greg. And I do see that Emmanuel has raised his hand.
Yes, before we jump into the issue papers, I would like to propose to nominate an additional advisor to the committee.
Okay. And as we spoke yesterday, there's two things. One is that if that person was agreed to by consensus, that they would need to be ready to join the negotiations, and they were supposed to let Cindy Jeffries from FMCS know that. Has that happened? You know?
Well, I spoke with this individual to confirm that they would be able to join immediately, and she said yes, she would be able to. I think that I wasn't aware that she had to contact Cindy. I did contacted Cindy yesterday, but I could have her also contact Cindy if we need to do that. But I know that she is ready and watching right now and available to participate.
Emmanuel, holding true with what we did yesterday with other nominees, I need to have that confirmed via email from the nominee. I did send you an email last night in response to your email regarding this, and I don't have anything from her at this point.
Okay, well, we can get that for you as soon as possible and hopefully move forward with proposing the nomination.
Okay, as soon as we have it from her, then we can go ahead and take care of that business, okay?
Okay, thank you.
You're welcome, thank you.
Then there's also something in the chat, can we get a CV, can we get a resume for the proposed person to get out like we did yesterday?
Yes, I can do that. I'll drop her resume in the chat right now.
Okay. And also wanted to acknowledge that Jessica Ranucci will be the primary for the legal aid constituency. So welcome. So I would, should we go ahead with the picking of consensus to add this advisor now? Should we table this?
I'm going to suggest that we table it until I receive that, in holding true with the process that was established yesterday. And then once I receive that from her, we will slot this item on the agenda in between issue papers.
Thank you, Cindy. I just want to be sure about that. Let's start off. Greg, I understand we were at the standards of administrative capability. You have the floor. Take it away.
Thank you, Kevin. Yes, we're still in administrative capability, and today we're going to pick up with M. These were the additions to the standards for administrative capability, and we're going to pick up with M. Does not engage in misrepresentations as defined in subpart F of this part, or aggressive recruitment as defined in subpart B. Subpart R of this part. And just as a little bit of background here, the last round of rulemaking that was in Table 1 included regulations on misrepresentation and aggressive recruiting practices that have been proposed in subparts F and R as part of the borrower defense issue. And we propose to include those misrepresentations and aggressive recruiting practices also in administrative capability, which would give the department additional opportunity to take action against schools that have committed those actions. We did send to our facilitators, and they have sent to you a couple of reference documents from Table 1. It was the most recently released public mandatory text was made public on the changes to subparts F and R. So I just wanted you to be able to have that as a reference when voting on this. Those obviously that was from a previous table. It wouldn't be appropriate to discuss that here at this table, but I did want you to have that information for reference. Do understand that that's just what was most recently proposed for session 3 of Table 1. So by no means indicative of, I don't believe consensus was reached on that one. So this is not necessarily the way it will absolutely appear in the notice of proposed rulemaking. So I just want you to understand this is the most recent text, but it's just for context for all of you. I just wanted you to have it as we think about this. So open it up for any discussions on that? On M.
Yes, we have Carolyn up first. Take it away, Carolyn. You have 3 minutes.
Thank you. So first of all, I think it's a good idea that the department has to include misrepresentations and aggressive recruitment in this section. And I'm supportive of it. I am concerned, however, that we don't yet know what the language is going to be that defines misrepresentations and aggressive recruitment, because we don't yet have the final or even proposed rule. We just have the suggested language from the earlier negotiated rulemaking. And the reason that that is of concern to me is that if it were, for example, more narrow than, for example, what would be misrepresentation or aggressive recruitment under a state law, that could actually have sort of a counterproductive effect of potentially narrowing, in theory, the department's discretion to take action against a school that was engaging in this kind of misconduct. So I'm not sure exactly how to resolve it, but I would be a little bit concerned about voting without knowing exactly what or reaching a consensus rather, without knowing what the language is. And I wanted to flag that concern. So for example, one could have a borrower defense discharge claim under a state law standard that would include something like an abusive or unfair practice that it could potentially be outside the scope of the aggressive recruitment in the language of whatever this rule is going to be. We don't know what the rule is yet. So that's my concern.
Thank you, Carolyn.
Thank you. I do understand that. I mean, the issue here is that obviously we will not have that rule while we're doing negotiations on this, and the department does consider it to be an important addition to administrative capability. So I do understand those concerns. I would suggest that it's true, we cannot guarantee exactly what the NPRM will say, but I think that this does give a pretty good idea of the direction the department was going, so I think that we know it does give a pretty good direction. I do want to point out that the misrep and aggressive recruiting proposed language in subparts F and R are not limited to BD. So these are separate subsections of the regulation. So it was on the table for BD, but not just related to BD. So do want to point that out. And that's what my ask here would be that we look at what's on these papers and try to make a decision moving forward. Because if we don't do that, then it really would preclude any vote on this issue during our table. So I don't want to do that. But I don't know, Steve, do you want to add anything to that? I'll just turn it over to council and see if it's not Steve. Steve is not my counsel here. It's I should know who my counsel is. Alejandro, any comments on that issue?
Actually, it is Steve, Greg. So
It is Steve. I'm sorry. I was
you get multiple advice here.
That's a
yeah,
good thing
there's
for
nothing
me.
to add to that. I mean, this is an incorporation by reference to a section that's not up for discussion in this group. So I think the point is noted that there is some uncertainty about what that means, but that's going to be resolved through notice and comment based on the Table 1 negotiations.
Thanks, Steve.
Okay, let's see. We have Yael up next.
So, Yael, before you start, I'm sorry to interrupt you. When we did roll call, Mr. David Peterson was not present. I do want to make note that he has now joined us. Thank you.
Welcome.
So my concern is the same concern that Carolyn raised, and I do want to see if we can figure something out a little bit more, because I'll tell you that it makes me very uncomfortable to vote on basically non-existent language, right? Like, it's a cross-reference to a section that doesn't exist, and I appreciate that this is sort of an accident of timing and not necessarily super avoidable, but I have kind of two thoughts. The first is, is there, to the extent that even having a sense of the department's proposed language with the understanding that it's going to go through notice and comment, and it might ultimately, the final rule may not look like the proposed rule. For me, at least, having a more concrete notion of what the department intends to propose would make me feel more comfortable voting on this issue, where otherwise we're really being asked to take a leap of faith that seems pretty difficult, frankly, to do. So one question that I had is there a sense that between now and the third week of these negotiations, Ed might be in a position to state more concretely what it intends to propose for the two sections that you circulated today? That's one question. And the other question is procedural. I realize this is probably a pretty aberrational scenario that we're in right now. Is there any kind of process by which we could vote on consensus with contingencies? Basically noting that in the event that the cross-references are to proposed language that reads substantially like what was circulated today, for example, that would be the basis for a consensus vote. And if that doesn't end up being the case, there's no consensus.
We'll take what I can say about the concerns. We'll take the concerns back. We'll take the concerns back and look at them and talk about that. I don't know what else we can get, for you by the time we get to our third session. So I'm not going to make any promises there beyond what we have here. To my knowledge, a consensus vote is, and Steve can step in and correct me here, but I don't think that there can be a contingency associated with a consensus vote. It's either consensus or no consensus. But if Steve wants to weigh in on that, he certainly may. But I can promise we'll take the concerns back, take a look at them. But I would like to say, for purposes of just the temperature check that I'd like to take for this, when people have had an opportunity to make comments, I would like us to think about it in terms of what we currently have. And again, as Steve pointed out, what was happened to table one is not up for discussion here. We cannot discuss that. I don't want to prejudice those proceedings or the development of regulations on those proceedings. So that we can just look at what we have here, because we're not taking a consensus vote today. And I promise to take it back and see if there's anything else we can get with respect to that.
Okay. Thank you, Greg. Barmak, you are up next.
So I share the concerns of Yael and Carolyn, but I also take the point that Greg just made, that we cannot renegotiate the misrepresentation reg at this proceeding. But it seems to me that one of my complaints about the proposed language is the overall meekness of it. When I look at the statutory language says that the Secretary is authorized to establish procedures and requirements relating to the administrative capacities of institutions of higher education, including consideration of past performance of institutions or persons in control of such institutions with respect to student aid programs. Sounds to me like if there was state action associated with the institution's conduct, that very much relates to the past performance of the institution, and that's a way of addressing whatever the misrepresentation regs may end up being at the federal level, along with any state action. So I suggest that we need to expand this language. It shouldn't focus, this kind of cherry picking of misconduct is problematic. I think any kind of bad behavior that raises alarm ought to be included here. And candidly, I think it actually has to reach the person in addition to the entity itself. So I suggest that we need some language to expand this to include other modes of bad past performance. In my book, that would also include institutional collapses. Institutions that have precipitously closed on students. There's very little to go after at that point, but it seems to me that at the least we can exclude the individuals involved with such institutions from being qualified to do it again under a new corporate banner.
Thanks, Barmak. If you have language you want to, I mean, I'm not certain if you're proposing another paragraph or you want to add something to M, but if you have
I'll submit language.
yeah, submit some language to us. We'll take a look at it. But
Thank you.
Thanks for your comments.
Okay, Brad, you're on deck. Go ahead.
Thanks. Good morning. I agree with Carolyn on concerns that the aggressive rulemaking definition has not been defined. But in addition, I also have concerns that the word substantial was left out in front of the word misrepresentation. The department is already authorized to take action against an institution that engages in a substantial misrepresentation. And that's because the substantial misrepresentation requires that a person could have reasonably relied on the statement to their detriment. And a simple misrepresentation, in contrast, includes any statement made by an employee of an institution to any member of the public that has the likelihood or tendency to mislead under the circumstances. It does not matter if that was intentional or inaccurate, and there is no requirement that a reasonable person could have relied on it or that it would have harmed them if they had. I would like to ask the department, why did they not include the word substantial in its wording?
Well, in thinking about this, again, we need to put it in the context of this is administrative capability, and note that the language does not engage in a misrepresentation, as defined in subpart F. It says does not engage in misrepresentations. What we're looking at with any type of administrative capability standard is, does the school engage in a pattern of misrepresentation? And I think what you said is how you characterize it is correct, per what's in subpart F. Here we're talking about that even if these are misrepresentations and not substantial misrepresentations, we believe that their occurrence on a regular basis does weigh on a determination of administrative capability.
Jessica, you have your hand up. You're next.
Thank you. I think from my perspective, again, as legal aid practitioner, I see people all the time who have been the victims of misrepresentations by their colleges. And I think that it's really important that we keep this definition of misrepresentation as broad as possible. And I think just one example of why it might be important is that often we see misrepresentations in generally applicable recruitment practices. There's a school where we saw a bunch of students enrolled in here in New York City that would drive a van around the city and would hand out flyers or say things in the van that weren't necessarily on their website. And I think it's important to give regulators like the department flexibility to identify any misrepresentations, regardless of without having to focus on the proof of the individual reliance piece. And I think, not to suggest this is what you're saying, but I think none of us want to see any institutions make any misrepresentations. And I think that that's really what our focus should be on.
Hey, Greg, are you ready for a temperature check on this particular, on M?
I am, and I just want to remind everybody that I'd like to, obviously, everybody comes at it from their own perspective, but take that temperature check in view of what we've said with, what we currently have for subparts F and R, understanding that this is not a consensus vote. Thank you.
So this is be for F and R and M?
Not for the, I'm just saying that when they take the temperature check on M, just do it in recognition of what we currently have for F and R, understanding that's not final rules, but it's the best. It's all we can go on right now. So we're just doing it on M.
Okay. I do see that Debbie, you do have your hand up. You have something you want to add?
I did. Thank you. I just wanted to flag. I had put a potential suggestion in the chat, which was the option of including language, including but not limited to.
Thank you for that. I would also make a quick note before we take the temperature check, just to encourage the negotiators. I know we have limited time and we want people to have comments. If there's specific questions that may make sense to put those in the chat, and that would help move things along. So That being said, if we go ahead and take a temperature check with thumbs for M and hold them high so we can see them, that'd be appreciated.
I'm sorry, can I ask a
Oh, go ahead.
clarifying question? What do we vote? I mean, I know it's not binding, but honestly, I don't even know what we're voting on. What are we voting on? The language as written, the language as contemplated in each individual negotiator's mind. I just don't know what the value is of.
It's just simply a temperature check of where the group is on. And remember, though, I mean, we're looking at that. We're not, the only reason I provided what was in what came from table 1 with respect to subparts F and R is to give you some context. We're not voting here. We're just taking a temperature check of what's here, what's just strictly what's in M. That's it. As it's written here.
Amanda.
I think just so I'm also understanding clearly how this impacts, because you said, Greg, to view this part of this issue paper currently, view this from a perspective without the papers that you added to us, subpart F and R, to view this only solely as the regs as they are in place and the definitions that we have currently, and take those new additions out. So now it's kind of like, what is the theory here? Where was the department viewing in adding this language from that perspective, as well as looking at, okay, this is the definition that we have currently, not being influenced by the new definitions that were discussed in a previous in the new, potential regs. Were they actually viewing it from that perspective? And that's why they included this line to add an additional, they view this as a tool to solve a problem. I'm just trying to understand the department's thinking was that their actual perspective?
No, what this is about, no, I'm not, we absolutely did propose this rule here in view of what we did at the previous table, at the table 1 with subpart R and subpart F. So no, they're not disassociated. We had that in mind. What I'm saying is that there are no existing regulations. Subpart R is entirely new. The changes we made at the subpart F, again, came from table 1. They're not in regulation yet. So it's kind of an odd juxtaposition, as Steve pointed out, with doing it this way. But so yeah, no, I'm not telling you to forget about what you read. Just to understand, you're not voting on that. You're not giving a temperature check rather on that. You're giving a temperature check on what's in M. And I was just trying to make people assuage people with respect to the other regs. But I don't want you to. Yes, we did. They are connected. The proposed rules there or that mandatory text and what we're looking at here. But nothing we're doing here affects those rules or what's proposed rather. What will be proposed in the NPRM, I should say.
Ellie, you were something to add?
Yeah, I just had a question. What outcomes can the department gain by having it here as well as having it in F and R? Like, is there something else that you would be able to achieve by having it here if it's already in those other 2 places?
Well, recall that, or I would have people note that what's in administrative capability is often reflects rules that are elsewhere in the regulations. This is a separate, when we talk about admin capability, it's not a finding the department often makes. It's we usually make it in conjunction with other serious issues a school has. So these just reflect on the administrative capability of an institution. So it's quite common in these, if you were to break down all these rules, that they are all referencing other areas of the regulations. So yes, we would still have what's in those subparts if we didn't include it here, but it allows us to if we're making analyzing, does the school have administrative capability? It folds that in.
But I guess in addition, that's understood. But I guess in addition to that, what would there be a different outcome if it was in the administrative responsibility section and not as opposed to being in the others? for the school?
Well, the outcome would be, so if, you know, in any compliance action, if the school, if we were to note that at an institution, they would obviously, the finding would reference, for instance, what is in subpart F or what is in subpart R. But if the department was making an overall finding of administrative capability, in addition, if there was an if there were an admin capability finding, it would be in addition to those other findings. So it would allow us to make that assessment that the school is not administratively capable.
Can I ask, I'm sorry, can I ask it one more way? So from a school's perspective, whether they have a finding as it relates to administrative capability or they have something that's an R and F, what does the school need to, is what the school needs to do to rectify those things different, I guess is my question. Or is it the same? Because ultimately it's the same finding.
Generally not, but understand that we would likely not, for one, if there was just that issue. When we do administrative capability, generally there are other issues involved on which we make the determination of administrative capability. So if you had a finding of administrative capability, the chances would be that there were many other things that went into that determination. But as far as resolving the finding related to misrepresentation or aggressive recruiting, no, that would probably be the same process you'd have to go through.
Sam and then Steve.
Thank you. So let me see if I'm understanding this correctly, or maybe ask it a little differently, because I think we're kind of down this rabbit hole a little bit. And I'm wondering, and based on Kelly's question, does it matter? Do we need to go here? I mean, the definitions in subpart F and R are going to happen through that other process, and we have no control of it. They're going to be what they're going to be. We're just simply cross-referencing here to whatever that is. So maybe that shouldn't hold us up from this decision here, because that decision is already made separately.
Well, let me, I think I'm just going to turn it over to Steve. He wants to make a comment, and maybe Steve can approach this from a little bit of a different angle. Go ahead, Steve.
Yeah, thanks, Greg. So often when the department is citing multiple violations of different regulatory requirements, we do reach the conclusion that the institution lacks administrative capability. When we see recurring patterns of violations, they tie together, and it's a pretty straightforward assertion that there's a failure of administrative capability at an institution. Some practices are so essential to the institution's duties to administer federal student aid funds appropriately that we want to just establish in the regulation that a violation of a provision like the aggressive recruiting or misrepresentation itself constitutes a separate administrative capability violation. It is a shorthand in a way, because the department could, do a more extensive documentation to tie the points together. But by doing it in the regulations, it's clearer that this is a central responsibility of the institution, and it can be a separate violation when you've got of the administrative capability requirement. I hope that helped.
Thank you, Steve. I kind of like to move ahead and take the take a little bit of temperature check here. I don't want to cut off anybody at all, but we are somewhat pressed for time. So
yeah, could we go ahead and yeah, sure. Can we go ahead and take the temperature check on M with a show of thumbs and hold them high so we can all see them? That'd be appreciated. I don't see any. Oh, there is a thumbs down, and there's one thumbs down. Would you care to say anything about why that is that you have the thumbs downs, or anything that could change at this point, or will that be something that you can put in writing for later?
Yes, we proposed definitions in the last rulemaking. We've yet to hear back from the department on those comments. So really, it's just the fact that we don't have a solid definition yet to review, and that's the concern. I'm not sure what I'm temperature checking on it without having the language.
Okay, thank you. Thanks for that. I do see that, Jessica, you have your hand up?
Yeah, I just, I think there are two issues for the department to take back on this now that you've made us do a temperature check. One is, what's your plan going forward with respect to the regulatory language here? And it sounds like maybe this is all we're ever going to get, and like you're going to make us do consensus on that. But I think trying to figure out if there's any other option would be great, because I think there's a lot of discomfort among this group of approving a section that's like exclusively a cross-reference to a section that doesn't exist. And then I think the second one is just to put a finer point on this question that other people have asked me over and over, which is like, what's the utility of this language? And I'm obviously, as I've said, I'm all for this. I think it's super important. I want to protect students, but I think without a clear explanation of how this language helps us do that, it's hard to understand why this is an important thing that we need. That being said, I'm all for the department's goals, but I think like the department coming with those two things next time would really help us.
Thank you. And I think, we've heard that, and obviously we have some work to do before the second session, and we'll take that back and see if we can, if we can get you something else in advance of that. Thank you.
Just as a housekeeping, we do have confirmation from Ms. Menditto, so it might make sense at this point to ask for any comment and then take a consensus whether whether she should be added as part of the negotiations. So we know we'd get to that, but we do have the confirmation as well. We have time, and we're finished with one. We want to try to jump in and figure out what that is. So I know Emmanuel had put that forward. Is there any? I see Emmanuel jumping on. You can go ahead and have the floor.
Thank you. So I would like to officially nominate Sue Menditto for an additional advisor role. Obviously, this role is not a voting role, so she won't be a part of the voting committee, but she will be able to advise us. I think it will be very important, and she will be a great resource for us when it comes to financial responsibility. That issue can be very weedy, and so if we have certain questions that may be difficult for even the department maybe to answer, I think Sue, from her experience, would be able to just be a valuable resource for us. I know that the first time the department did advisors was the most recent negotiated rulemaking session. And so I think that this is still new, and having this additional advisor role will only help us and not harm us. So if you have not gotten a chance to read the bio that I put in the chat, I just want to quickly go through who Sue is. So Sue Menditto, she works for the National Association of College and University Business Officers, which is also known as NACUBO. And she's the expert on accounting standards, financial accounting and reporting, managerial analysis, and financial viability. She has been with NACUBO for 19 years and is charged with fulfilling higher education advocacy needs with the Governmental Accounting Standards Board, which is GASB, the Financial Accounting Standards Board, known as FASB, and the Association of International Certified Public Accountants, AICPA, in the Department of Education, actually. As such, she is considered one of the foremost experts on the federal financial responsibility standards, and her presence on this negotiating committee is essential to positive outcomes for this topic area. She has represented higher education on the Governmental Accounting Standards Advisory Council from 2006 to 2012, AICPA's Revenue Recognition Task Force from 2016 to 2017, and Department of Education's Financial Responsibility Subcommittee in 2017-2018, where she de facto became a leader of that particular subcommittee in helping them formulate what the language was that we saw in the 2019 Bar Defense Regulations. So with that, I'm happy to take any questions, or we could just move forward to the consensus vote, but I think she'll be a great addition to help us.
Jessica.
Yeah, just a quick question. Are you proposing that she's an advisor just on the financial responsibility piece or on the whole NEGREG? I don't even know if that's an option. I just thought you mentioned specifically financial responsibility.
Yes, I'm proposing just specifically financial responsibility.
Brad, you're up.
Yeah, so I'm just curious. I don't know Sue, but I know we do have Dave McClintock on as an accounting advisor for this committee. So I'm just not sure how her background, albeit, she is in a public accounting background, how it's different than Dave McClintock's and what additional value she may add.
So I would say the additional value that she brings is from her experience of being a negotiator before, from her 19 years of working with institutions of higher education specifically and knowing directly what their needs are at a more grassroots level, and being able to bring all of that experience with her in her knowledge of financial responsibility solely, beyond just the composite score calculations and figuring out what those aspects are. But I think having that additional voice and knowledge will only be a benefit to us, because when we get to that topic, it is indeed very weedy. And I know the department has indicated they don't want to really discuss the calculation of the composite score at this moment, but that conversation will come up at some point in time. And I just think it'll be helpful for us to be able to reference her if we need to.
I agree. The discussion around composite score is going to be important. Still not 100% sure the value in addition to Dave McClintock, but always open to additional resources from accountants.
Brad, if I could just interject there, with him representing from an auditing and accounting perspective, Sue really brings knowledge of financial responsibility specifically with all the negotiations that we did in 2019, 18, I think it was. So she has more experience there in the specific conversation that we will be having, as opposed to auditing from a general perspective.
Thank you, Kelly. That's helpful.
One point of order real quick is that when people raise their hands, they'll be called on it in the order that they're putting their hands up. So I just want to let everyone know that Jamie had her hand up. Just going forward, and I appreciate the comment, but we want to try to keep things orderly. So Jamie, you're up next, and then Barma. And you're on mute, Jamie.
I'm just wondering if Cindy or the department can explain how we use advisors, because there are lots of complicated topics where we go back to others who know issues. I'm not taking a position yes or no on this one. This might just be a good moment to explain. Do we call on advisors? Does the department or the facilitator call on advisors? Do they say, I have something I want to offer, even if we didn't think of calling on them? I'm just trying to think how that will affect the process. It is a complicated topic. There are many like that where we're expected to, sift or bring the thoughts. So in order to make a smart decision about this, I could use some backup.
Greg, you want me to field that?
Yes, please. Go ahead.
Okay. All right. So the role of the advisors is to assist the committee. All right. They are there for you to ask for information, data, analysis, whatever it is you need. And those your requests would be sent to me. I will send them to the advisors. You're free to ask questions and have dialogue with the advisors during session. Most generally, they will need time to compile any information you ask for. So we ask that you would either put that in the chat and or send it to me so that I can send it on to them. When they have that, they'll come, they'll have the ability to speak and present whatever information they're able to obtain for you. Feel free to engage them. That's what they're there for. They're there for you to be able to get the information and that you need to have this. And I know the department, as with the last neg reg and this one, put a lot of thought into, how best broadly to assist you with a full, people who have a full range. And so, as I understand, Emmanuel, he's suggesting an additional financial advisor be invited or added to the committee. Financial advisors or any committee, when they're added, committee members added, both in the beginning or at this point, are expected to participate fully in the negotiated rulemaking and be available to get you the information that you need. Okay. They are your resource. You are free to talk with them. You are free to meet with them. You are free to send them written requests, verbal requests during session, however you need to get the information. Does that help, Jamie and the committee? Yeah. All right.
Greg, go ahead.
Sorry, I didn't hear the last comment.
No, I just had, you had your hand up, or were you?
Oh, thank you. Yes, I have a hand up. Yes, indeed, I did. I didn't. I just want to say, from the department's perspective, we certainly do not oppose the addition. But I want to make it clear with respect to financial responsibility that the department will not entertain adding composite scores to our discussions on this table. It is not to suggest that we don't think the topic is important. We certainly do. We understand that the current composite scores go back a number of years, and we are looking at them and looking at the possibility of adding that to a future table. But we just don't have the wherewithal to do it now. And those of you who were around at the time know that in advance of those rules, of the rules where we put composite scores into place, that we had a fairly substantial analysis done by a large accounting firm, and there was a lot of preparation for that has not been done in advance of this table. So this is not to say that I don't believe that this individual could add expertise in a lot of different areas. I just wanted to make it clear that the department is not considering putting composite scores on this table. Thank you.
Thank you. Bob, before we get to you real quick, I do see Johnson with his hand up. I just wanted to let everyone know that he is switching out for Jessica Ranucci for the legal aid. Okay, so Barmak, take it away. You have the floor.
Yeah, I don't quite know how I feel about this, primarily because an essential qualification of an advisor beyond technical expertise, which Ms. Mendito certainly has, is independence. And I kind of worry about, and in fact, the fact that she was herself a negotiator sort of speaks to the fact that she represented a sector, she represented a stakeholder in previous conversations. The thought sort of went through my head when Brad brought up the availability of Mr. McClintock to address financial responsibility. I have the same concern, perfectly needy of expertise, but I worry about expertise sort of bleeding into normative recommendations that are not necessarily objective, that are simply that represent a very sophisticated technical presentation of a point of view rather than of basic facts. So this is a little vexing, quite honestly.
Anne?
So I would underscore Barmak's comments. I also want to go back to, I thought where Jamie was going, which is that there are lots of complicated issues that we're going to face. And as our discussions just over, a day and a half have already shown. So I do think, we've got advisors. We also are all here. We've been selected as negotiators from specific constituencies. We can draw upon those constituencies for information as well. I'm just hesitant about going down a road where we begin to add advisor after advisor on specialized topics. That just strikes me as not the spirit of what we're trying to do.
I just want to I see Johnson in the queue, and then once Johnson has given his comment, we're going to go ahead and take a consensus check on adding Miss Mendito. Okay, so Johnson, welcome, and you have the floor.
Hi, thank you. I often hear from my clients that, the process is opaque. They don't understand it, and they have a point of view. And I feel like getting experts into this sort of issue of, oh, well, the institution has to do this and this and this, and that I'm worried that it's going to become a discussion about why an institution cannot do something. They have representatives here at the table on that issue. I'm sure this person's very qualified and knows a lot of stuff, but I at this late, I wouldn't say late stage, but I just don't understand her role completely here, other than, as Barmak said, being an advocate of a position. And I think there are plenty of advocates at the table here to represent that position. Thank you.
Thank you, Johnson. So we're going to go, Greg, do you think it's a good idea to take the consensus check now?
Yes, I do.
Okay, so if everyone could vote with their thumbs, as we've done before, and hold them high on adding Ms. Mendito as an advisor for specifically the financial responsibility, that'd be great, so we can see them all. Okay, we have several thumbs down, so Ms. Mendito will not be added as an advisor. Thank you. Thanks for going through that discussion. So I'll turn it back to you, Greg. Where would you like to go next? I know we just finished M.
Right. Thank you. I almost lost track of myself during the whole discussion there, but yeah. So we're going to look at paragraph T. We're talking about was former paragraph P, developing and following adequate procedures to evaluate the validity of a high school of a student's high school completion if the institution or the secretary has reason to believe that the high school diploma is not valid or was not obtained from an entity that provides secondary school education. I want to point out that we have what we're doing here is proposing clarifications to existing regulations that are related to the validity of a student's high school diploma to address some gaps we've seen with the actions of unscrupulous institutions. Specifically, we are aware of institutions that intentionally look the other way or arrange for diplomas with what might be referred to as diploma mills that are definitely not valid. These proposed rules would clarify how institutions must evaluate those diplomas, including obtaining documentation from the school, such as transcripts, written descriptions of course requirements, or written statements from the school. The proposed rules also specify when a high school diploma will be considered invalid. Specifically, we propose to clarify that a diploma is not valid if it does not meet the state's requirements or is not recognized by the state. If the Department of State or a court has determined the credential invalid or the diploma was obtained from an entity that requires little or no education or coursework to obtain the diploma, including through a test that does not meet department requirements for GED or equivalent of a high school diploma. So that's a little background for it. Let's walk through the change itself. You can see here that we've retained the most of the language from the existing regulation, existing paragraph P. We have added develops and follows adequate procedures, and we are now defining what those adequate procedures must be. So adequate procedures to evaluate the validity of a student's high school completion must include obtaining documentation from the high school that confirms the validity of the high school diploma, including at least the following. And remember that all of this, what precedes all of this is that these are procedures to evaluate the high school diploma if the institution or the secretary has reason to believe that the high school diploma is not valid or was not obtained from an entity that provides secondary school education. This is not a requirement for schools to collect high school diplomas in every instance. So given then that what that language is in T, let's look at what the adequate procedures are. Obtaining documentation from a high school that confirms the validity of the high school diploma would include one of the following, either transcripts written descriptions of course requirements, or written and signed statements by principals or executive officers at the high school attesting to the rigor and quality of the coursework at the high school. And if the high school is regulated or overseen by a state agency, confirming with or receiving documentation from that agency that the high school is recognized or meets requirements established by that agency. And lastly, a high school diploma is not valid if it is not recognized or does not meet the requirements established by the appropriate state agency in which the high school is located, has been determined to be invalid by the department, the appropriate state agency in which the school was located, or through a court proceeding, or was obtained from an entity that requires little or no coursework to obtain a high school diploma, including through a test that does not meet the requirements for the recognized equivalent of a high school diploma found in 34 CFR 600.2. So that's those are the proposed rules. I'll open the floor for comments, questions.
Okay, I see Amanda, you are on the clock. Go ahead.
I just have a procedural question but I do have questions on this part, but just another procedural question. If we do have questions on sections of this issue paper that we've already passed on, when is the appropriate time to bring maybe that discussion up or that question up? Would it be now before we get into another issue, and is there allowable time? So that's my first question. My second question on this issue in particular is, this is just a clarifying question. These procedures can you confirm with me if they're mostly done, the burden is on the institution. I'm wondering if the education department understands how institutions receive this information, like is it mostly on their burden to communicate with high schools and work with high schools to receive these processes, or is it really the institution working with the student and kind of pushing these regulations onto them to then conduct most of the work, to then go and work with their high schools and conduct all of this basically the student is really doing all the work to ensure these federal regulations. I'm wondering whether there's understanding or experience of who's the burden, facing this. I know that the institution has to provide the information, but really what's happening on the ground of who's the burden of ensuring this information is being provided to the education department.
To your first question, as far as if there's something we've discussed previously, I don't want to preclude discussion of something we've gone over previously, but as you are aware, we have a pretty full agenda, and I'd like to get through, or try to get through our agenda. If you have specific questions, you can feel free to, or comments on something we've previously discussed, you can feel free to submit those to the facilitator, and we certainly will make every effort to answer them, or if there's something you want us to include on table 2. I'm sorry, this is table 2, session 2 of table 2. But at this point, I don't think we have the time resource to go back and revisit areas we've already touched, but certainly if you have a question or something, feel free to submit it. If there is time at the end of this week and we do have time to go back, I have no objection to that. Regarding your question about the high school diploma and whose responsibility it is. So, and this hasn't changed, and then a student indicates on the FAFSA if he or she has a high school diploma. That's essentially a self-certifying question. There's no database against which that is checked. We don't require institutions to collect high school diplomas for every student. Some schools do, obviously. Schools depends on how schools admit. Many institutions are going to get the transcripts and final transcripts for every student that goes to that institution, so they will have that as a matter of course. What we're talking about here is, again, those instances where there's where the school has reason to doubt the validity of the high school diploma. So the school would have to validate that by obtaining documentation from the high school. Now, there's no, as far as the burden, who the burden falls on, there's no, I mean, so the rule would be that so in an instance where an institution has reason to question a student's high school diploma, or whether that student has completed high school, they would obviously approach the student about that. There would be no requirement here. A school can certainly assist a student in trying to obtain that documentation, but there's nothing in these regulations that would require the school to do the school would be required to obtain that documentation through some means, whether it's the students applying it or if they want to go get it themselves. But the burden to the institution falls on them to say this is not valid for these reasons, or we can't, or we don't know, we have reason to question the validity. And if they need these things that are written here, transcripts, written descriptions, of course the school could always go out and request that, but I think in most of these cases there probably would be student involvement in trying to obtain this, and that's because the student was unable to present something that indicated that what he or she had was a valid high school diploma. And I totally get that could be difficult, especially for students who spend a long time since they've been to high school. Maybe they've moved around a lot and don't really even remember where that was. But where we do feel that there's a compelling need where this is in doubt to obtain this information.
Before I get to you, Barmak, I'm going to ask Cindy Jeffries from FMCS. She has something she'd like to add.
Yeah, I just want to add to what Greg said about going back and addressing things that we've moved on from. I want to remind the negotiators that this is session 1. The goal here is to get through all of the issue papers to try to have some meaningful dialogue. Session 2, that is going to continue. So all of these issues do get circled back to, provided that we can get through them initially. And then week 3 generally is where most of the consensus takes place. If not, I mean, it could take place a little before if you have some that you think clearly you're ready to move on. And so there will be more times to address these and have conversation about them, especially as we progress with updated reg text that comes from the department based on things that you submit to them. So if you do have questions that you want us to forward to the department, please feel free to send them to me, as well as we encourage you to put your proposals in text, and the department prefers that you utilize Word to do that, and forward those to me, and we'll get them to the department so that they have ample time to look at that and see whether or not they can incorporate things into their next round of reg text that they'll be presenting. So I hope that additional information is helpful.
Thank you very much, Cindy. Appreciate it. Barmak, you have the floor.
So in a previous life, when I used to do admissions policy, we dealt with the problem from hell, that is high school diploma mills. So what I can tell you is that Romanet 1 under T1 is utterly meaningless, because a diploma mill will provide you spectacular transcripts. They very typically have very extensive course listings and course bulletins, and they will sign anything you ask them to sign. So that all of that is just word salad. That doesn't really substantively add anything by way of actual protection. Romanet 2 is helpful. When you go to subsection 2, certainly Romanet 1 is meaningful. Romanet 2 is meaningful. Romanet 3 is problematic because, of course, there is no consensus on what the definition of an education is. Folks in education often refer to the holy trinity of education being curriculum, instruction, and assessment. And really the meat of that is instruction. So I would really strongly urge you to replace the word education with instruction in that subsection. And then I would also add a Romanet 4 to that section, where the secretary would view any high school diploma, any diplomas from an unaccredited high school that has a business relationship with the post-secondary institution that is admitting the student. That was one of the biggest loopholes that we used to see 10, 15 years ago, was that they would set up fake high schools that charged nothing, mostly because the college was basically paying the school to rubber stamp diplomas. So I would add a Romanet 4 there.
Thanks, Barmack. Well, could you please submit that, and we'll definitely consider that.
You're killing me.
Well, you know, it's the burden has to be placed on someone, Barmack, and so I'm going to place it squarely on you since you made the suggestion. I won't. I will probably remember that, but it does help if we get the language. So you wanted to change education to instruction in Romanet 3, right? And you wanted to add a Romanet 4 that addresses if the high school is unaccredited and has some type of a business relationship with the institution, correct?
Yes, but I'll submit language.
Right. I mean, our note takers will capture that, but yeah, please do submit.
And just for everybody to know that Jessica is on deck next. Go ahead, Jessica.
Thanks. I just want to reiterate, I think, the diploma mill problem is a real one, and I appreciate the department taking a step to do that. As a legal aid practitioner, we see literally thousands of ability to benefit discharges at my organization. I guess I was just wondering if the department could speak a little bit more to why this and why here? Like, why do you, it's sort of the question that I think Kelly asked last time, like, why do you think administrative capability is the right place to do this? And how do you think it's going to make a difference here?
Well, we still have the definitions of a recognized equivalent of a high school diploma in other sections of the regulation, and also under student eligibility requirements to obtain a high school diploma. Why is it here? Well, because again, this is a tool. Administrative capability generally is a tool that we use, and going back to the way Steve described it, when we've made other findings at an institution that are generally serious, then it keys to this overall finding of administrative capability, and it actually puts into this codifies in regulation for the first time, really, these steps that we now have to determine if the high school diploma is not valid, and even if we felt it made the most sense to do it here in this discussion of administrative capability, especially since this was the part of the regulation we were opening up on this table. It does get it into regulation that that a high school diploma is not valid if it doesn't meet these three criteria. So even though we address this in other areas of the regs, it is here and codifies it here, so we can hold an institution to that where the institution had cause to believe, or the department has cause to believe that it's not valid. So I hope that answers your question.
Steve.
Yeah, I'm just going to add to what Greg said, making sure that I'm not muted. So if you look at the standard of conduct in the Department of Regulations, the institution is held to the standard of being a fiduciary. The federal student aid funds it administers, it does so on behalf of its students. Those are not the institution's funds when it draws them down. They are students' funds. And then the institution applies those funds to the accounts at the institution and is responsible for dispersing the additional funds to the student for living expenses that were calculated under the regulations. But the baseline for all of that is the institution's determination that the student is eligible. And one of the fundamental requirements of student eligibility, as Greg mentioned, is that the student has a high school diploma or some equivalency that satisfies the requirements under the Title IV of the HEA. And if this is not a baseline finding for holding an institution, a determination the institution is not administratively capable, I don't know what is, right? And this is actually putting it in the right place to make this connection to the primary responsibility of the institution to make sure the students are eligible.
Thanks, Steve. Appreciate it. Brad, I see your hand up.
Thank you, Kevin. Just had a few clarifying questions for either you or Greg. Obviously, no one wants to allow diploma mills, but I think some of these details here could be challenging for institutions. The department is requiring the institution to reach out to the high school. What if the high school won't cooperate, or what if the high school is closed? You know, in those instances, if the institution was forced to deny admission to the student, I could see this being particularly challenging for non-traditional students that went to high school a while ago, who lives in an area that has had high schools closed. So could you help me on that first piece, and I've got a follow-up.
Well, I can see that it might be difficult to obtain the documentation necessary. I don't want to belittle that, but remember that what precedes all of what's in 1 and 2 is that we start with this what's in T, and we need to always review that this is in instances where the institution or the secretary has reason to believe the high school diploma is not valid. So with this, the first step there would be the institution. This is in an instance where you already have cause to believe this is not a valid high school diploma. Again, I don't think that what the regulations would require was that, as Steve said, this keys back to student eligibility rather. The student is not eligible if the student doesn't. If you have reason to believe that this credential might be invalid, at that point, that is not an eligible student until it's determined that reasonably determined that it is indeed valid. So the steps in acquiring the documentation, the school would have to get it to obtain the documentation. Again, how the school does that is not, does it do it through the student? Does it assist the student? We're not really regulating that here. We're saying that the school has to obtain that documentation. I don't know what we can do in instances where the student is unable to attain that. If the student is unable to attain it, then it might be that the situation could be such that it is indeed invalid, and in that case, the student is not an eligible student. So I don't know that we can entirely address that.
Follow up on that, and thank you for your comments. If the assumption is the registrar has the bandwidth or ability to know the names of each high school considered an issue, I'm not sure they would have that bandwidth or expectation. But if we were unable to get an answer, are we assuming we should deny admission in all instances if they won't respond?
Well, again, this is a situation where you already have cause to believe that what the student, we're not requiring that you obtain a high school diploma for every student, right? So we're looking at instances where you believe there to be a problem or a belief that it is not valid. So at that point, yes, the student is not valid until you have cause to believe it's invalid. That needs to be resolved. So if for whatever reason if it couldn't be resolved in such a way that you obtain the documentation necessary to confirm the validity of it, then yes, that student would just not be eligible.
And then one final question here. It says in here that we should expect that high school principals and executive officers write letters to colleges and universities attesting to the rigor of their coursework. It seems like an atypical request. See high schools being hesitant about providing that kind of information. Why would the department want the letter to be from a principal or executive officer?
Well, what we're doing here is, consider that it's obtaining documentation from a high school that includes at least one of the following. And what we were trying to do here is provide options. So we're not saying necessarily it has to be that. That is an option to give schools some flexibility in what types of documentation it obtains in instances where it feels that or it has cause to believe rather that the high school diploma is not valid.
Just not sure we were going to get a lot of response if it's at that level, but I'll defer questions at this time.
No, point taken. I think in some cases it might be difficult to obtain those statements. But we do have other options there. For instance, transcripts. I think in most cases somebody would have a transcript of their time at high school.
Sorry about that. I had to get myself on mute. We have two more people in the queue, and then I'm going to go ahead and call on them, and then I would go ahead and ask to move for a temperature check on T. So the two people in the queue, first up, we have Debbie.
Thank you. I too appreciate the goal here, and just had a couple questions about how this works currently from the secretary's perspective. In terms of, how frequently does the secretary have cause to believe that a transcript or a high school diploma might be invalid? What contributes to those beliefs, and how are institutions notified? Or is there like a process like verification flags with the FAFSA, where schools get kind of pushed some information?
So is what you're asking here? How would schools be made aware of the department's belief that a high school diploma is not valid?
And also how common it is, like so trying to get at the sense of like how we can think of some instances where this might be really challenging. I'm trying to understand how frequently they would arise.
Well, it's not our only concern, but I think one of our chief concerns here is our instances where, and this has happened. We do have instances of this where an unscrupulous institution has entered into arrangements. I think Barmack brought that up, that was particularly problematic. He had seen that, and he's absolutely right that it does occur, that some institutions will enter into arrangements with an entity they clearly know is not a legitimate provider of high school education, and funnel the students from that entity into the school. This would allow us to give us considerably more teeth to go after that practice, which is just inexcusable on any count. It's clearly just a circumvention of what's required by law and what's in regulation. So we would pick that up here. As far as, and then probably where schools would be made aware from the department, you'll recall that in 2010 when we were doing program integrity regulations, the department had indicated its interest in providing lists of diploma mills, and we are interested in pursuing. I know it's been pointed out to us that we never did it. It's not an easy thing to do, but we are thinking about going back and trying to provide that. That wouldn't be an exhaustive list, of course. It wouldn't mean that any entity not on that list is automatically valid, but that would assist schools and be a way of us informing institutions that like a specific entity or entities are not providing high school diplomas, valid high school diplomas.
Marvin, you have the floor.
Yes, I just want to clarify that I do not believe a lot of big public institutions collect the high school transcript. And I just recognize that would be a burden, administrative burden, regulatory burden on schools. So I just want to be clear on what the expectations is as this is written. Are you saying that all schools will now have to start collecting the final high school transcript? And will that be subject to some type of audit To me, it's another verification burden that we're putting on schools. And I certainly understand the concerns about, false transcripts, but I'm just recognizing it's an administrative burden on schools to start digging in on some of this.
So to answer your question, is the department through these regulations requiring schools to collect high school diplomas and transcripts? The unequivocal answer to that is no, we are not. That we still key to what's in T, where evaluate the validity of the student's high school completion if the institution or the secretary has reason to believe high school diploma is not valid or was obtained from an entity that provides or was not obtained from an entity that provides secondary school education. So this is not a requirement across the board to collect transcripts or to collect high school diplomas. We are aware that there are many institutions that do not do that they rely upon the student's assertion on the FAFSA that he or she has a high school diploma, as long as there is nothing to contradict that. What we're talking about here are instances where you have reason to believe that that there's a problem. And I've seen schools, I've actually talked to schools where they become worried about a particular high school, or it could be a provider of high school of high school diplomas that they see a lot of their students coming from. That they begin to doubt the validity of this entity. So at that point, then this would certainly kick in, but it is not a requirement to, in every instance, evaluate the transcripts of a student or to obtain written statements or anything that's in paragraph 1. Subparagraph 1. Sorry.
Okay, I just mentioned a little while ago that we were going to take 2 more comments. I've seen a few hands shoot up. Just wanted to make sure that whoever has their hand up that they have something new to add, and if so, could they please keep their comments brief as possible, as we do want to move things along. So that being said, Beverly, you have your hand up.
Excuse me, I don't really have anything else to add, but let me just say that as a former president, we did have interim processes to determine if a high school diploma looked invalid, and that's the texture, and you contact the institution. Certainly there are questions asked of students, but it's a shared kind of responsibility, and I don't have any unrest with any of the others, but there is a process and it matters.
Thank you, Beverly. I really appreciate you pointing out the shared responsibility aspect of it, because I think that's where I was trying to go, and you said that very well.
Thanks, Beverly. Kelly, and then Debbie.
First, I want to stress that I agree with the importance of the validity of high school diplomas in this. I have a couple of recommendations based on the fact that I think what I've heard Greg say is that the validity of, or the responsibility for the validity of this is with the institution, and that this only occurs when there's some question as to whether or not the diploma is not valid. So my first recommendation would be in number 1, that you change the word must to shall, or remove it, because by saying must, you're basically saying that the institution must do these things, which you said that the institution is not required to collect transcripts. So I think that word needs to come out. And the second recommendation would be to strike number 2 altogether, because you're saying that the high school diploma is not valid if, but the responsibility of determining whether or not it's valid or not is on the institution. So I think removing that might help.
You would. I'm just trying to clarify, and I want to be sure that I say. First of all, we don't like to use the word shall anymore, because if it's a requirement of the school to do it, then that we feel it's incumbent on us to make that clear that it's a must. And remember, we're saying the school must evaluate this, and that the evaluation must include. So when I say must include, yes, the burden falls on the institution to do this. I'll take an absurd example. I'm the student and this institution questions the validity of my high school diploma. We're not saying here that the student can sit back and say, you know what? Yeah, you're questioning, so it's up to you to it's up to the U school to document that I'm eligible. No, the documentation has to be received by the school, but it may be that the student has to participate in that process of getting it. I mean, ultimately, it is the school's responsibility to have it in order to validate the diploma. But quite frankly, if a school questioned it and the student said, you know, I'm not going to do anything, it's up to you to try to contact my school and all that. I don't think there's anything incumbent upon the school to do that. That situation would be the student is not eligible at that point until this is obtained.
But I think what Marvin said earlier was that the bigger public schools are relying on the certification of the student, not so much in the fact that the school is validating the validity of at least one of the following, which would include transcripts and et cetera, right? So you're not saying that the institution must do these things. You're giving examples of things that they can do in order to, ascertain the validity of something. And the biggest one that he mentioned is not listed here.
I'm sorry, which was what?
I think what he said was that the students are, can I defer to him to answer that question?
Self-certification on the FAFSA is what schools are relying on.
Correct. And as I pointed out earlier, these proposed rules, do not preclude that. They do not preclude relying upon the FAFSA. They do not require that you collect transcripts for everybody. Remember, it goes back to where it's only where you have reason to believe the high school diploma was not valid. In most cases where you're relying upon the FAFSA, or even where you're receiving transcripts, you probably don't have cause to believe that it's not valid. So where that does not exist, that's reason to believe it's not valid, then none of this kicks in. So this only comes after there is. So we're not talking about a routine requirement to collect transcripts or written descriptions. This is only where you have reason to believe the high school diploma is not valid, or you've been informed by Ed that a particular in the instance of a mill or something where we may inform you that those diplomas are not valid. Does that make sense? I hope I've explained that properly.
Barmak, is this something new? And if so, could it be quick?
Very quick.
Thank you.
The issue is not, we're conflating two distinct questions here. The FAFSA certification and the kind of routine practice, which at the vast majority of institutions does not include the collection of final transcripts, has to do with whether the student graduated. And yes, there are some students who may not have actually graduated, who may slip through but that's a different problem than the entire high school being fake. And that's the reason why number 2 is really necessary there. This is not a mandate on ensuring that every student that you may admit or enroll actually graduated from a legitimate school. That's the norm, and that whatever practices institutions engage in today would be adequate. It's in those hopefully exceptional cases where the entire high school is a fake construct that this provision kicks in, and a burden then is added to the institution, at least along these lines, to establish the legitimacy, not of whether the actual graduation occurred. Graduation did occur. The issue is the school real. So I think those are two distinct issues that are being addressed quite adequately here under 2.
Thank you, Barmak. That was very well said. I like the way you said that. That's exactly what we're doing.
Craig, would you like to proceed for a temperature check on T at this point?
I think yes.
Okay. Everyone, you know what to do. Go ahead with the temperature check with your thumbs. And so raise them high so we all can see them. Okay. It seems that everyone is in agreement on T for temperature check. Thank you for that. Greg, how would you like to proceed?
Okay, I believe our schedule calls for us to move on to a discussion of gainful employment. So that's what we'll take up next. So I'll give everybody a minute to get that paper in front of them. And I want to say at the outset, before we get into the discussion of gainful employment here, that unlike with the other issue papers we've given you thus far, and will give you before the end of this week, we don't have any proposed mandatory text or red line in here for you. We are proposing to bring back subpart Q, which, as you're aware, was taken down. And what we're hoping to do in this, with respect to gainful employment at this session, is to get some feedback from you. Sort of, for those of you who participated in egg regs in the past, we have in the past used the first week as basically a listening session. We've departed from that somewhat and tried to provide a mandatory text where we can. We don't have that yet here for you. So this is, you'll notice that we have a number of discussion questions. We would like to receive your feedback on that. So I'll introduce the topic. After I do so, I'm just going to kind of step back and let the facilitators present these questions, and then we really like to get some feedback from you. And I want to try to get through all of them because they're all important for us to have to take a check of the negotiators here to see where they want to go as we formulate the mandatory text going into the next table. So just as a matter of introduction, we know.
I'm sorry, can I interrupt quickly, because I hope we're not done with administrative capability. If you recall at the beginning, I pointed out that I thought there were omissions that we need to address. Could I very quickly just cite two of them and then be tasked with drafting language before we finish administrative capability?
Yeah, well, you can go ahead and tell us briefly what they are, but I would request that you put those in writing to us, and we'll bring them up. Bring them up at the next session. But go ahead.
Two issues that are proving problematic time and again with regard to the participation of bad actors in Title IV. One of which has to do, this sort of is a segue to financial responsibility, but I think it belongs here in administrative capability. The department, we've seen from past gigantic collapses of publicly traded institutions, that whatever the substantive criteria the department uses to establish compliance and financial responsibility, those seem to be annual events, that there is no real-time monitoring to ensure that the institution that might have adequately satisfied the requirements at a given point in time continues to be compliant with the requirements. So what I'd like to add is language to the administrative capability section that would require the institution and its executives, people exercising substantial control, to report any material adverse events to the department, within 30 days or something. That would prevent the kind of scenario where an institution may satisfy financial responsibility requirements and then be looted by insiders and leave the department holding the bag. Tends to be pretty standard in commercial law, and it seems to me that it would make a lot of sense to require that of institutions. The other trigger that I hope we can add perhaps to the language in M would be that when institutions lose eligibility in other federal programs which loss has consequences for Title IV, it seems to me those need to be factored into administrative capability as well. An institution that suddenly loses eligibility for GI, this is what we're very familiar with, the institution that suddenly loses eligibility for GI Bill benefits because of findings of the SAA, typically forces all of the students who relied on the GI Bill benefit when they enrolled to take out loans. That has consequences for Title IV, and it seems to me that loss of eligibility ought to be reported to and acted upon by the department. I think we can add this to the misrepresentation section, but I just wanted to flag it.
Thank you. Yeah, please submit that and we'll take a look at it. Thanks.
Just a few things before we get to the next topic. Just to announce that, let's see, Carney King is now in for Ernest Iswago, representing student borrowers. Johnson Tyler is back in for Jessica Ranucci. We have Emmanuel Guillory in for Kelly Perry for the private nonprofits, and Barmack will remain as a primary for this discussion.
Just a point of clarification, Kevin. Ernest Iswago is at the table.
Oh, okay.
Arnie was there for the end of that last conversation, so Ernest is back.
Got it. Thank you. Trying to keep track of that. Thank you, Cindy.
Okay, you have the, I'm sorry. Yeah, we have the summary of the issue in front of you. Just some highlights here that with what's in statute. The Higher Education Act requires some programs and institutions that be generally all proprietary institutions and any non-degree programs that are at public or private institutions to prepare students for gainful employment in a recognized occupation in order to be eligible for Title IV aid. We talk about that for many years. The standards by which institutions could demonstrate compliance were undefined. We go back to in 2011, the department conducted rulemaking and issued a regulation establishing standards for gainful employment. It was based in part on the debt of graduates that was incurred for the program relative to the earnings that they received after completion. That regulation was reissued in 2014 following a court challenge, and it was based on similar debt to earnings structures. When the data were first released in 2017, over 800 programs collectively enrolling thousands of students did not pass the GE standards. In 2019, the department rescinded the 2014 rule almost in its entirety. The department, however, remains concerned about the prevalence of programs that fail to help students obtain sufficiently remunerative employment to justify the investment of their time and resources. So we do discuss a growing body of academic research that has identified persistent problems with the GE programs, including some very low or negative labor market returns for graduates. So we do have concerns about that. We point out that most recently available data that is published via the College Scorecard show that the median cumulative loan debt of students in many programs is quite high compared to the amounts of money that the students earn. And we say, for example, median cumulative borrowing levels exceed median annual earnings at about 12% of undergraduate programs. And we note here that or 9% among public and nonprofit. Among proprietary institutions, however, the analogous figures are 28% for associate and 42% for bachelor's degrees. Multiple studies have found that accounting for differences in student characteristics, borrower outcomes like repayment rates and the likelihood of default are worse in the proprietary sector. And finally, research indicates that federal accountability efforts can be effective in driving improved student outcomes, especially for students who attend for-profit colleges. So we're seeking feedback on the overall state of GE here, including the greatest problems that students who enroll in GE programs currently face. We're looking at what would be an appropriate framework for these GE standards, including metrics we could utilize, sanctions that might be applied where these standards are not met. And finally, we are going to request feedback on the need for improved consumer information about the outcomes, as well as GE programs' failure to meet required standards. So we do have a number of questions here. We are interested in establishing criteria to determine how an applicable program can demonstrate that it's preparing students for gainful employment in a recognized occupation. And that is required by the statutes. The department seeks to promulgate regulations promoting better labor market outcomes, create value for students, investments in higher education, protect students from acquiring debts they cannot afford to repay, and finally safeguard the interests of taxpayers. So just give the first question here for you to consider, and then we'll open it up. So the first question we have here is, Before I give these questions, we're going to try, I want to get through all of them, so I don't want to cut off debate on any of this. Please, as our facilitators constantly remind us, if you have which is a good thing, to make certain that if you have a comment that it is something new that has not already been brought up, as we do want to get through these. So the first one is what metric or metrics, what thresholds, pass-fail cutoff points in those metrics best distinguish between programs that prepare students for gainful employment versus those that do not, including at different credential levels. For instance, we seek feedback on the use of repayment rates, debt to earnings rates, earnings thresholds, and other measures. And we ask, should the department include non-completers in any of these metrics? How would the department assign non-completers to programs, and what metrics would be most suitable? So consider that. I'll step back and we'll open the floor for comments on question number 1.
Thank you, Greg. Just to reiterate, this is it's a big conversation. There's a lot of questions. If we can try to limit the discussion to the specific questions as we go through, that'd be helpful. And as Greg mentioned, if there are specific comments or other things you'd like to put in writing, feel free to do so. The department is seeking your input and ideas. So we'll go ahead and start off. We have Barmak. You have your hand up. No, you don't have your hand up. Okay. Then we have Brad.
There are
Brad, you're
people
up.
ahead of me.
I see Yael as first on my screen, Kevin.
Oh, okay. I'm sorry. It's backwards for me. I apologize. Yael, you're up.
No.
Sorry.
No problem. Adam and I submitted initial comments yesterday, so I won't rehash all of them, but it's certainly relevant to the first questions here about the metrics that should be employed. So I do want to briefly reiterate our position that the 2014 gainful employment rule should be the department's baseline for the GREGs that come out of this process. The 2014 rule was the product of multiple thorough and I would say painstaking rulemaking processes. It established accountability metrics, the debt to earnings metric in particular, that provided critical protection to vulnerable students, and I think notably withstood both judicial scrutiny and the test of implementation. The department's rescission of the 2014 rule under the previous administration was unreasoned. The department does not need to be bound by it. And I'd note, I just think there's simply no reason to reinvent the wheel here. I think it may well be the case that in the intervening years, we've identified potential opportunities for additional protections and additional metrics, potentially an earnings threshold. And these types of additions should be considered, but the modifications should be minimal to the 2014 baseline, and additional metrics should be just that, additions. I'd like to just give our, I think, unique perspective, right? Our view that Ed should be effectively reinstating the 2014 rule comes from years of experience by my office and Adam's office and AGs across the country addressing the fallout from the lack of safeguards and standards that predated the 2014 rule. We know that a large segment of for-profit institutions enrolled students in our states with false promises and basically left them buried in debt with no meaningful career prospects. I can say confidently from our experience with these investigations and enforcement actions that had the 2014 rule been in effect, it would have prevented a lot of schools from continuing to operate programs that harm borrowers. And my final point here is that I really think is important to frame the discussion is just a reminder that an institution's access to Title IV funds is not an entitlement, it's a privilege. And it's the responsibility of the department to ensure that only those schools that provide students with meaningful educations are allowed that privilege. So, we have the imperative here to make sure that we're not reinventing the wheel, that we're doing things that are far-reaching and robust, and that students are no longer left holding the bag for institutional and regulatory failures. So thank you for the opportunity.
Thank you, Yael. Let's see, we have Johnson, you're up next.
No, actually,
I think Brad was next.
Yes, Brad is next.
I'm sorry, my screen is a little funky, so I apologize.
I'll feed it to you.
All right, thank you. Appreciate it.
Good morning. On gainful employment, I have two main opening points relating to accountability and statutory authority that I would like to discuss before going into the specific gainful employment questions. First, the department should develop an accountability system that protects all students by promoting good student outcomes across all programs and all of higher education. Any regulation that only applies to gainful employment programs only will fail to protect over 75% of the students in higher education because it will only cover students who attend proprietary schools or enroll in non-degree programs. Respectfully, it does not make sense to pour an enormous amount of effort and resources into an accountability framework that protects less than a quarter of its students. There is also no question that the students in all sectors would benefit from this protection. In every sector, there are programs that serve students well, and there are those that do not. It is also worth noting that the department is on record supporting accountability measures that apply across sectors. Last June, Secretary Cardona confirmed his view to the House Education and Labor Committee that all post-secondary institutions, regardless of tax status, should be treated the same under the law. I'll drop that video into the chat so everyone can listen to it over lunch. And just a few months ago at an FSA conference, Undersecretary Koval committed to addressing student debt issues and ensuring equity for all students. Lines between our sectors are also blurring. Recently, proprietary schools have converted to nonprofit institutions. Public schools have acquired or merged with former proprietary institutions, and many nonprofits and public schools are now partnering with private for-profit online program manager companies called OPMs. On January 14th, Senator Warren sent a letter to a group of OPM companies seeking accountability for all students attending over 300 OPM partnered programs offered at nonprofit and public institutions. These institutions have partnered with the for-profit OPMs to allow them to manage their marketing, recruiting, and admissions processes in exchange for a significant portion of the nonprofit program's tuition. We wholeheartedly agree with Secretary Cardona that all students, regardless of sector or background or tax status, deserve equal protection. If we are serious about protecting students during this rulemaking, then we need to protect all students. I will get back in queue to make my second point regarding statutory authority next. Thank you.
Thank you, Brad. Let's see if we got this right. Johnson, you're up.
Thanks. I agree with Yale's assessment that the 2014 provides a framework with a bunch of categories, metrics that no one is a tripwire. You need to really fail in one or fail in a number of them. I think it's really useful. I would add to that the high school earnings as a metric. That's something that's easily understandable by lawmakers, legislators. You should be earning more than a high school diploma after you go to school, make the investment of going to college. I would like to just reframe this a little bit in that there is just a terrible amount of debt that's taken out by schools that don't provide quality. And there does need to be a metric. I have file cabinets filled with clients whose I've been telling, your job is to manage your loan. You're never going to repay this, because a place like the Art Institute has really swindled a number of my clients, other schools as well. So I think there has to be a metric, and we have to go back to the statutory authority. Since at least 1978, gainful employment's been in the statute, and it's applied to proprietary schools and non-degree granting programs. Congress is well aware of that. It's capable of changing it if they started viewing the value of those institutions differently. They've chosen not to, and gainful employment really needs to just address that issue. Thank you.
Thank you, Johnson. Barma?
Yes, thank you. First of all, I was a negotiator for the 2014 gainful rule. I was not satisfied with it at the time, but I want to associate myself with the comments Yael made and Johnson made, that what we have is likely to be far better than anything we can generate on an issue among so many others in this very truncated process that we're undertaking now. So I agree that the 2014 rule ought to be the core of whatever this committee ends up producing. Now, having said that, I also remind folks that the statutory language for gainful employment represents an eligibility criterion. The department chose back in 2014 to essentially let institutions offer programs and then kick them out if they failed this criterion. I think we have an obligation for purpose of protecting both students and taxpayers to also add to the 2014 language some provisions on the front end to at least give us a reasonable assurance that the program does in fact prepare the students it intends to enroll for gainful employment in a recognized occupation. I think that ought to be severable from the conditions that are articulated in the 2014 rule that are post facto, but there are some things we can do on the front end to prevent victimization before people get plugged in to failing programs years later. It's a very backwards way of doing things. You know, Brad, I have enormous empathy for your perspective. I do agree that all programs ought to be held accountable, but I worry a little bit about making the perfect the enemy of the good. The idea that we should protect no one unless we protect everyone, you know, is just an impractical one. And frankly, these programs are in fact where so many problems have concentrated. So there is good empirical reason to start here. And furthermore, and I'm curious what your statutory interpretation is, the statute very clearly only gives the secretary authority to address the programs that the 2014 rule does address. We can go to Congress and ask to expand it, et cetera, but at the moment, we have to operate within the confines of the statutory authority that the secretary does have. Thank you.
Thank you, and Barmack, I appreciate it. I will address your comment when I'm back up.
Thank you. Thanks, Barmack. Let's see here, Ernest, you are next. You have the floor.
Thank you. First, just want to take a moment to agree with Gail's comments, Johnson's comments, Barmack's comments related to the 2014 rule being the benchmark here. I'm sorry, being the baseline, not benchmark. And as to the second part of this question, I hate to kind of comment on a question with a question, but I would love to get context on why the department wouldn't include non-completers in any of the metrics. I mean, Greg, if you wouldn't mind speaking to that, I'm just trying to get context on, you know, why that's a question to begin with.
Well, the department, we're seeking comment on, you know, should we include non-completers? Previously, in the last time we had the rule, the 2014 rule, it only took into consideration those who had completed the programs, and I think that there are, you know, admittedly there are arguments on all sides of that. One of the things, you know, and if you look at the way the rule was put into effect, you know, it does look at people who have completed a credential, and so there is, when you look at only completers, it does give you this. Your baseline is those who've actually completed the program and will be expected to go out and earn income related to that credential which they have obtained. So it's probably makes things more compact. It makes it easier for us to assign students to a program, certainly. And if we departed from that and went to include even those who were not completers, I'm not arguing one way or the other for it. I'm simply saying that there are some, there would be some challenges in doing that, and we're asking here for feedback on whether or not we should go in that direction. But I think the reasons why back in 14, we went with completers, is that it is a, if you're looking at tying the, if you're looking at tying earnings to somebody who's practicing the actual profession, then there is a more direct tie, I think, to someone who's actually completed. Which is not to say that, you know, we should look at people who don't complete and say that too could be that is not saying that is not an indication of a problem with the program, because it very well may be. So we're just throwing it out there for comment. And you know, if to read. You know, certainly anybody could go back and read the preambles to the final, to both the NPRM and the final rule for the 14 regulations, and get more of a handle for the discussion on that. I say Steve was there at the time. Ask Steve if he wants to add anything to that.
Steve, you're up.
Okay. Thanks. Just a couple of things. As Greg noted, I mean, there was some discussion about whether completers should be a part of the prior GE framework, and I think there are persuasive arguments that if you're going to evaluate a program's ability to prepare students for gainful employment and a recognized occupation, it makes sense to only look at the students that actually complete that program when you're doing that assessment. I will say there's another anomaly that kind of comes into play as well, which is if you've got a lot of students that drop out quickly in a program and their earnings are not dissimilar from the program graduates, you're going to make a program look better, because the students that drop out early are going to have substantially less debt that's going to be considered compared to those earnings. So it's, you know, there's a lot of pieces in the framework, and that's why we're asking for comments this time as well.
I would just respond really quick by saying thank you. I appreciate that context, and it provides a lot to think about, and kind of emphasize a point Barmack made about thinking through ways that through this rule and otherwise we can think about how essentially how we're bolstering this rule and other regulations to consider protecting as many students as possible in respects to kind of triggers for when when GE other programs take effect, and essentially making sure that we're thinking through how we can limit as much damage to students as possible. And yeah, that's all I'll say for now.
You, Ernest. I do see Advisor Adam Looney had his hand up. If that's okay, if we go to him and then go right back into the queue. Does that make sense? Okay, Adam, and then we'll go back in the queue, and Debbie, you be up next.
Thanks. I just want to jump in on a couple of these topics because I had some background that I want to share. So one issue on the topic of completers and non-completers, you know, I think back in 2014 and before that, part of the issue was how quickly the administrative capacity to assign somebody to a program quickly, to understand, you know, if you're a freshman or a first-year student or something like that, how do we know when somebody's in a program? But on the other hand, so it seemed like there were some challenges, and as Steve said, like it was in some ways appropriate to assign somebody to a program only after they completed. On the other hand, an enormous number of students drop out of programs before they complete them. That is in some ways it's a negative outcome, and it impacts their subsequent earnings. Likewise, they accumulate less debt, which can bias the debt to earnings metric. So there is a strong case for including non-completers in these metrics because they affect the outcomes and they reflect the, some elements of how the institution is serving the student. The other thing I wanted to say beyond just the completers versus non-completers was the other element of the potential earnings metric, an accountability metric, is the earnings premium, or the earnings that the student earns after they leave school. So that the 2014 rule included a debt to earnings metric, which certainly is one potential pillar of an accountability system. But there are also schools where students leave the program with a lot of debt, but don't boost their earnings. And so there are programs that can fail students on a different dimension by not leaving them with an education that allows them to do better than, for example, a high school graduate does. And so another potential metric could be used that is widely available, easily produced by the Department of the Treasury, are those earnings outcomes. Thank you.
Thank you. And then back to the queue. Let's see, Debbie, you're up.
Thank you. I was going to make a broader point, which I'll say in a minute, but just on the point of non-completers in particular, since we're getting into that, it seems to me that the answer about non-completers in particular depends entirely on the metric you're using and the logic that's undergirding the metric. So I have like in the 2011 rule, non-completers were excluded from debt to earnings, including the repayment rates. Some good logic to that. So I just think it's hard to have that conversation about non-completers when it's divorced from a particular metric. My overall comment was really about just echoing the calls to really think about the 2014 rule as the baseline for these discussions. And particularly because of how heavily pressure tested that rule was and that the core provisions have survived significant scrutiny. I mean, I think there's room for discussing some of the details and some of the questions in here, but I don't want to lose sight of the harms that are created by the lack of stability in this regulatory area. I think if the goal of this rule is to set reasonable standards that we think institutions can and should comply with, and that will leave students better off, we are just not doing anyone any favors by moving the ball all the time and regulating, unregulating, re-regulating. We need to set a standard and we need to go forward, and that's what's best all around. And clearly not good for students, clearly not good for institutions. And of course, it also creates substantial pressure on state agencies. State agencies are often the first line of defense when it comes to helping students through closures, program closures, school closures, helping students find new programs that they can transfer into, and find financial relief when needed. So, in particularly related to gainful employment, there were a lot of states across the country, California being one of them, that wanted to regulate their own state rule in light of the rescission of the federal rule in recent years. And a lot of states, including California, need to start from scratch if they're going to do it. States generally don't have the administrative data sets that the federal government does, and that the federal rule really heavily relied on. So I think while it's very commendable that states want to step up in this way, and I know they're all trying, it's just simply less efficient to do that at the state level. So that is why I really suggest starting with the 2014 rule, kind of tried and true, just to get back to a place where we can have some stability.
Thank you, Debbie. Amanda, you have the floor.
I just wanted to also echo and come out with the majority of the statements about the 2014 rule reinstating the framework there. Obviously, I think we can come together, and hopefully we can come together to make improvements or adjustments and updates according to what we're seeing in the field and the outcomes students are making. And ultimately, I think it's, why I think civil rights groups, and from our perspective, why we support the 2014 rule is for reasons that I will be able to articulate in the limited time. But I think the first one is that when we think about the Higher Education Act and its original promise, it was to ensure that all Americans would have access to a high quality education that then would that would hopefully, once they reach that finish line and attain those credits and that degree, that would then, and they would be able to enter the workforce or the labor market with accurate wages that would help them, go through and achieve economic stability or move through into the middle class. It was a tool viewed by Lyndon B. Johnson that would hopefully lessen inequality, income inequality, right? We were entering a stage of more industrialization. There was a need to fill the gap and to open access to educational opportunities, not just for some Americans, but for all Americans, especially those who were in the poverty line. And isn't it great? We should be all excited to see that that did happen. However, there's actors within this market that are disproportionately using that promise and that hope to some communities who are trying to attain it and enroll and achieve that dream, and kind of twisting it on its head. And I think that good racial policy that is equitable has to be targeted, has to go where the data and the numbers are showing us where we need to go into help communities who are otherwise have been disenfranchised for more than 3 to 4 generations in this country. And the 2014 rule did that. It's shown proven mechanisms that it's helped those specific communities. It's helped women.
30 seconds.
It's helped Black and Latino communities be given back that promise that they were stolen of. So I think that's kind of where we're coming from, why the a proven racial equity tool, this is the best tool we can have. Of course, it needs additional discussion and updates and improvements, but that's really where, if this administration wants to do something for racial equity, this is where it needs, the floor needs to begin, and it's clear and apparent, the evidence is there. Those 20, Brad, I know I have like limited time. When it hurts me to hear.
Amanda, your time is up. Sorry.
24% of the students, those are important, 24% of the students. Okay, bye.
Okay, thank you, Amanda. Brad, you're next.
Thank you. And as a reminder, my first point covered developing an accountability system that protects all students in all programs across all of higher education. I want to thank Barmac and Amanda for agreeing that all students in all sectors need protection. We hope everyone agrees to this basic standard. We believe we had a solid way in the statute to cover this comment. I want to emphasize that the department absolutely has statutory authority to create a universal quality assurance system that could include components of the previous 2014 GE metrics as being referenced around this committee. In other words, there is no reason it has to attach its accountability system to the gainful employment language, which severely limits its reach. It's true that as long as the department decides to connect its accountability framework to gainful employment programs only, the accountability measures will only apply to non-degree programs and those offered by proprietary institutions. That's because those are the only types of programs that are required to lead to gainful employment under the HEA. But there is a simple fix. Instead of attaching its accountability framework to the gainful employment concept, the department could just build the framework under its Quality Assurance Authority. Student Defense actually published a report in 2020 that spelled out exactly how the Higher Education Act provides the department the ability to protect all students across all institutions participating in the direct loan program at an institutional or programmatic level. And those institutions and programs are promoting strong outcomes. According to the report, Section 454A of the Higher Education Act delegates to the Secretary the authority to implement a quality assurance system. Quality assurance system could include measures like repayment rates, debt to earning rates, and earning thresholds, and those measures could apply to all institutions participating in the direct loan program to strengthen the higher education accountability. I'll drop the report in the chat for people to review during lunch. Meanwhile, there is no evidence that Congress ever intended for the department to base an entire accountability system on the phrase gainful employment. The term has existed in the Higher Education Act since its inception in 1965, nearly 57 years. Not once in those 57 years, which includes 8 full reauthorizations, did Congress define or attribute this phrase as setting labor market thresholds such as debt to earning measure. Consequently, there is a good argument that trying to attach an accountability framework to the gainful employment language in the HEA exceeds the department's authority. All of this to say, if we're serious about protecting students during this rulemaking, that we need to protect all students, including the 75% of the students that were protected under the previous gainful employment rule. And we should do this under the authority clearly granted by Congress.
Thank you, Brad. Next up, we have Emmanuel.
Yes, I just wanted to quickly keep in mind that I hear that folks are proposing that we start with the 2014 rules as the base. And so if we are to do something like that, then I just wanted to remind people that the department, did have some issues implementing the 2014 rule. And what I mean by that is it just took a little bit longer than what was expected for things to actually happen. So, for example, there was an original due date of when the completers list would come out, and then the challenges to the completers list would come out, and then the draft debt to earnings rates, and the final debt to earnings rates. And, because I think the department undertook something that is still needed, maybe additional capacity or resources to implement timely, there was a delay and lag in when things actually took place versus when they initially thought they would take place. So I'm not saying that's ultimately a bad thing per se. I'm just saying that with the 2014 rule, it's quite complicated. And so I just wanted to, remind folks of that if we were to go back to that rule. But also that particular rule obviously had a lot of comments as it relates to how do we hold these programs accountable when you are looking at their annual percentages of 8% if the student has a loan repayment rate more than 8% of their annual income, then they potentially are not passing, or if it's more than 20% of the discretionary income, they were not passing, versus 2010 rule, it was 12 and it was 30. And obviously in the former GE 2014 rule, you did have your passing and your zone and your failing. And of course, a new construct could have that same metric, but I wanted to also keep in mind that even though a student may go through a particular program, especially a student of color, who could take on more debt because of so many other reasons, once they actually enter the labor market, they are at a disadvantage than their white peers as well. And so the latest fourth quarter 21 average data, Bureau of Labor and Statistics is telling us that if you're 16 years or older, your median weekly earnings for a man is $1,103. Your median weekly earnings for a woman is $930.
30 seconds, Emmanuel.
And if we look at the numbers based on race, white, it's 1,030, Black is 805, Asian is 1,384, and Hispanic or Latino is $799. So if we're looking at the earnings too, that is also a factor that's going to impact the programs and what would actually be passing or failing.
Thank you, Emmanuel. We have Anne.
I don't even know if this is allowable in this framework, but it seems like there's a lot of support around this particular question in providing feedback to the department that the 2014 standards should be the baseline. And I didn't know if there would be value in sort of doing a temperature check from the negotiators, because my understanding of these open-ended questions is that they are designed to inform the department's thinking about the language it'll propose. So I just wanted to throw that out there.
Yeah, if there's, we could certainly entertain a quick temperature check on. So the question would be just saying, indicating general support, general understanding that wouldn't be standing up the exact same rules, but general support for the 2014 rule as a, I think it's been described as a baseline for other rules. So I'm willing to entertain that.
We have two more people to comment, and then if we could take, you want to take the temperature check at that point for the first question, and then we can move to the next. Does that make sense? Correct?
I'm going to suggest that we do that temperature check on the baseline right now, and then take Jalen and Barmack, and then move on to question 2 as we are fast approaching the lunchtime.
Sounds good, Cindy. I agree with that.
Sounds great. Thanks for jumping in, Cindy. And then we can take a temperature check through thumbs. Make sure you raise them high. We can see them. no. I'm sorry, I did see there is one thumbs down. Okay, got that. Thank you.
Thank you, everybody.
Yes, Kevin, the thumbs down is for the statutory reasons described in my second part of my statement, not the metrics themselves if applied to everyone.
Got it. Thank you for clarifying, Brad. As we mentioned, and just to tee up to Jalen, he is joining the table. He is in for Carolyn Fast for the Consumer Advocate. So Jalen, you have the floor, and then Barmack.
Kevin, I'm curious, is it allowed to do a temperature check on the committee's thoughts around protecting all students in all programs at all institutions? Would that be an appropriate temperature check that we could take?
I would like not to do that at this moment.
Is there a reason why we can't request that temperature check, Greg?
Greg, let me just address, the facilitators are charged with administering the process and the protocols. So we will take that under advisement, Brad, and get back to you.
I would love to do that before the end of the session today, if possible. Cindy. Thank you.
Okay. And we will have a response for you later. Thank you.
Thanks, Cindy. Jalen?
Yeah, thank you. So I want to start by saying, yes, obviously we agree with 2014 should be the baseline for moving forward with this. What I would like to also see, be interested to see, is the data on the earnings threshold as well. But also what I want to do is prevent another Baker's College from reoccurring. What we have to look at is see here is that a lot of the students that attend these universities are non-traditional students that are obtaining these degrees. So these are students of color. These are full-time students. Some have families, some have children that come into these programs to obtain a degree. But what we're also seeing is that they are also taking out the most debt as well to complete this program at a speed that is told to them by the university or by that particular program that they can receive it by. So what I would encourage us to do is to be able to have more accountability and enforcement from the department to protect these borrowers. We are trying to bridge the racial wealth gap, and the GED programs like Baker's College are only increasing the racial disparities that the student debt crisis has brought forward.
Thank you, Jalen. Barmack?
Yeah, I was going to make other points, but I want to engage the point that Brad is raising before a final ruling. It sounds to, and in fact, this is more of a procedural issue for the facilitators, perhaps. Brad, it sounds like you simply do not believe that the task we have been charged with, which is to develop regulations for gainful employment under the existing statute, is the task we ought to be engaged in. You know, there are lots of other things I do believe in, right? I mean, I do believe in equality. I believe in racial justice. There's lots of other things we could talk about and take votes on, but we're not here to just, address abstract philosophical points, as relevant as they may be, but rather to operate within the scope of the charge this committee has, and that is to develop regulations pursuant to the statutory authority that has been cited. Part D is not under consideration here as far as I'm concerned. So as much as I like the student defense paper, that is not something we have any authority to address in this proceeding. And it really sort of brings up the issue of good faith to some extent. If you really don't believe if you don't believe in the task we're engaged in, I just wonder why you'd want to negotiate it. I hope we all agree that we're here to develop regulations. So, we can argue over what those regulations should be, but the idea that the effort itself is not legitimate is kind of problematic for me. One other point I want to make with regard to the disparate impact of the rule on minority communities based on fundamental injustices within the labor market, which are very real. Look, that should not be used as an excuse to saddle minorities with more debt. I'm hoping that what we develop will end up incentivizing practices that, in recognition of the fundamental unfairness and discrimination that minorities face in the labor market, maybe that the rule we develop will create incentives not to finance so much of their education with debt. So I don't know that you're doing anybody any favor in saying that, you know, women earn less or African Americans face discrimination in terms of wages, and therefore they ought to be allowed to borrow even more. I feel like that's or that we should allow institutions to package them with more debt. So you know, we need to be mindful of the two sides of that argument, it seems to me.
30 seconds.
Thank you, Barmak. We, in the interest of time, let's say it's 12:22 Eastern. There is Johnson and Brad in the queue. We can hear from them, and then I think that should be able to wrap up question number one. I do see Emmanuel. So if you can keep your comments short, that'd be appreciated. So Johnson, you have the floor.
Hi, so I was in the 2017 rulemaking and negotiated rulemaking on gainful employment. And one of the issues that came up was if a lot of people drop out of a program, you're not going to get a statistically valid amount of information to put into a GE metric. You need to have a certain number of people. And so if you're only counting completers, you're not actually assessing the value of that program. So it's a nuanced thing. I don't have a specific statistically valid way of assessing it, but I do think, as Debbie mentioned, when you're talking about completers and non-completers, you have to think of what the metric is you're using, what you're trying to measure. If a lot of students are dropping out of a school and that doesn't get measured in any way in the metric, that's going to be a problem because they're obviously not getting supported by the school, but also they may be paying an exorbitant amount even when they drop out for the little bit that they were there.
Thank you. Brad and then Emmanuel. And that should be wrap it up, I believe.
Well, thank you. I'll respond to Barmak's question that I am definitely here in good faith. And we've been asked to negotiate something that is not even been issued a red line yet. So we've got 9 questions that we've been given to develop a framework for gainful employment. And we have provided a statutory way to the department to include protections for all students at all institutions in all programs. And we think that is of utmost importance. And there are good and bad players, I'm sure, in every part of the sector within higher education. We're not here to try and deny that, but we're here to protect all students. And I think it's contrary to what Undersecretary Cavall emphasized in his comments yesterday, the Secretary's comments last summer. They both have come out and said that all students need protection. And that's why I'm here, to ensure that the metrics that this committee agrees to can be applied fairly and equitably to all students. That's the end goal.
Emmanuel, you're up.
I just want to quickly clarify that I by no means am advocating that students take on more debt. When I went through the statistics, I just want to state the facts and the numbers of what we have today and the data that we can see from the earnings and the inequities in that, even for students of color who have degrees still earn less than their white peers. And so I wanted to just make sure that that was articulated to my colleagues, but not by any means am I here to support, then there should still be programs that are failing these students and they're going into more debt and being harmed even more. I also wanted to clearly state that the most recent 2014 rule, the private nonprofit sector had the most programs that were under consideration in the rule. We had over 18,000 programs. For-profit sector had over 9,000 programs. And so with that being said, we will have a lot of non-degree programs in our sector that will be held accountable to this. I want to make sure that they are held accountable accordingly, 100%. But I just want to make sure that we are taking into consideration what's happening to these students once they do complete the program and then go into the labor market and the inequities that exist based on, unfortunately, the color of their skin.
Thank you, Emmanuel. You may be accurate on the number of programs, and I have not researched that information, but according to the latest IPIDS research we performed, 75% of total students, not on a program basis, but total students were not protected under the previous gainful employment. Proprietary institutions currently today, according to 2019 IPEDS data, only make up 8% of the total students attending higher education institutions today. About 1.2 million out of somewhere in the 19 to 19.5 total student range. That means there's about 18.2 million students attending nonprofit and public institutions, going somewhere else besides a proprietary institution to get their education. We believe that all those students deserve the same protections that have been given to the proprietary industry. And to have 75% of students not covered by this rule is just unfortunate. And I have a feeling that many of the students that we might hear from in the public comment period could speak to the fact that they've been unable to be gainfully employed after graduating some programs from these nonprofits. So again, it's not the metrics. We want to be fair and equitable to all students, but if 75% are not covered, that's a problem. We need to address that problem as a committee.
Thank you. Beverly, we only have 2 minutes before lunch, so if you could make it quick, we'd appreciate it. Beverly, you're up.
I just want to reference something that Emmanuel said, and I put it in the chat. But the reference to debt to earnings and looking at the earning capacity based on race, ethnicity, and gender refer to the weight of that if used as a metric, because those are factors over which I don't think the students or institutions largely have any control. These are results and outcomes of injustices that still remain in our America today.
Thank you, Beverly. I want to thank everyone for their comments in the morning session. Just want to confirm that we're going to be picking up with question 2 after lunch. We have a lunch scheduled from 12:30 to 1 o'clock, so the live feed will go down and then come back up at 1 o'clock.